is an honor and a pleasure for me to be here. An honor because the Latin American countries have been active participants of UNCITRAL since its founding in 1966. We have adopted a number of conventions, and we have established close cooperation with colleagues from the Americas. And a pleasure because I see around here at the table and in the audience friends who have been with us co-workers in the field of trade law unification and harmonization. Now, the importance, why the importance of our work? We always thought, and we liked it, we like to think that our work is the other side of peace and stability. That is economic development. And economic development, where does commercial law fit? It is a small stone, but the foundation stone of economic development. In recent years, our work has become politically more visible, and of course for us this is a mixed blessing because we are a professional organization which produces a lot of work. We like to have the resources to do our work, but we would not like to be in the middle of political fights, which would in a way create a problem for our work. The visibility in a way is demonstrated by the recent visit, the first visit of a Secretary General of the United Nations to UNCITRAL in Vienna last December, where he told us in very clear and unequivocal terms that our work in the overall scene of the United Nations fits in two big discussions. One is sustainable development, and the other is rule of law. So UNCITRAL recently became one of the two commissions of the United Nations. The other one is the International Law Commission, which reports every year to the General Assembly of the United Nations on rule of law matters, on the general hypothesis, generally accepted hypothesis that there cannot be rule of law without equitable commercial laws. And that's where UNCITRAL works fits in the overall big political scene, if you like, of the world and the United Nations. We are a modest subcommittee of the General Assembly, and our mandate is unification and harmonization of the law of international trade, which includes not only private national law, conflict of laws rules, but also substantive, material commercial law rules. Not only private law, but also public law, for example, procurement. Not only material commercial law, but also civil procedure law, like arbitration. So it is the law of international trade. We have 60 member states from all regions of the world. And of course, every member state of the United Nations can participate in our work on an equal footing. There is no voting in UNCITRAL. We have the principle of consensus, which means that decisions are made by consensus by all states. Consensus not in the sense of one state vetoing the decisions and in a way blocking a decision, UNCITRAL being unable to conclude on any text. But we start from what seems to be the majority view, and then we go on and try to address the concerns of the rest in the room to the extent that if they are not 100% happy, at least they can live with the result. We have 6 working groups, which subcommittees of the plenary. Each one is devoted to one topic, and the participation in the committees and in the working group is, in terms of countries and organizations, the same, but of course different people, different experts. In terms of organizations, we have intergovernmental organizations like UNCITRAL and the Hague Conference, of course, the World Bank, and non-governmental organizations like the International Chamber of Commerce and International Bar Association. And we have the Secretariat, just to complete the picture of UNCITRAL, UNCITRAL, a subcommittee of the General Assembly, the Secretariat, a part of the UN Office of Legal Affairs, part of the Secretariat of the United Nations. A small group of experts serving the Commission and the working groups. Now, what is the kind of work of UNCITRAL in general? What are the products that emanate from the work of UNCITRAL? You have a number of conventions to international treaties. These we consider normally instruments of unification of law. The law of states is the same, except to the extent otherwise provided by the conventions. Because the most well-known and successful is the United Nations Convention on Contracts for the International Sale of Goods, the CASG, 85 member states or so. Not so successful, but again very close to my heart, a convention which has influenced the development of the law but has not been widely ratified is the United Nations Convention on the Assignment of Receivables in International Trade. How has it influenced the law? It has become the model of law reform at the national level. Its principles have been implemented in national law, but as a convention it has not entered into force yet. We have a number of model laws. Model laws we consider as instruments of harmonization. That is, the law is not the same, but it's compatible. Model law countries, in a way, can speak to each other. The legal institutions, transactions completed under the law of one state are recognized under the law of one state. As a result of this harmonization, we have a promotion of international trade, which is the ultimate goal of UNCITRAL. Then we have, of course, well-known model laws on international commercial arbitration, conciliation, cross-border insolvency, and privately financed infrastructure projects. A third category of texts of products of UNCITRAL are the legislative guides. It's a further step in the area of harmonization of the law, as we call it, soft law approach. Legislative guide analyzes issues that need to be addressed by legislation, with comparative advantages and disadvantages, or one or the other approach, and then there's a conclusion to the legislator, which the legislator may take or not. Of course, if you like, the international legitimacy of the work of UNCITRAL is part of the international legitimacy of the work of the United Nations. The work of UNCITRAL is not binding on states. It is recommended by the Commission and then by the General Assembly to states, and then member states are free to ratify a convention or adopt a model law through their own parliamentary process. And the texts are to be applied and interpreted by national courts. So we have full respect for state sovereignty and separation of powers at the state level. A next type of product of the work of UNCITRAL is a contractual guide. The contractual guide is a text which provides guidance not to the legislator, issues that need to be addressed in the law, but to parties, issues that need to be addressed in a contract, for example, on infrastructure projects or major construction contracts. What are the issues that need to be addressed? How are they to be addressed based on international best practices? And of course we have the contractual rules, the UNCITRAL arbitration and conciliation rules, which are not law, they have the value of a contract. They are incorporated by reference in the contracts of parties. So UNCITRAL, product text of UNCITRAL, what is the work of UNCITRAL right now? I mentioned six working groups. I will go through them very quickly because of the shortage of time. Working group 1 is considering a text on the incorporation of micro-businesses. This is a proposal to UNCITRAL by a Latin American country, Colombia, and the work will start next year, probably in March, in New York. I failed to mention that the meetings of UNCITRAL, the Commission and the working groups alternate between Vienna and New York. Why? In order to make it possible for as many states to participate as possible. Why? Because we are about global unification and harmonization of the law of international trade. Why is then all states, why do we have a consensus? Again, because a good point is a good point whether it's made by a big state or by a small state. And a commission like UNCITRAL can ignore a good point only at its own peril. That is the wisdom, at least, of us. Working Group 2, Arbitration and Conciliation. The arbitration, international commercial arbitration, is what it is for many reasons. Some of those reasons are the New York Convention, which was done before UNCITRAL, but is supervised by UNCITRAL, monitored by UNCITRAL, and of course the UNCITRAL model law on international commercial arbitration and the UNCITRAL arbitration rules. Now, this arbitration working group of UNCITRAL is preparing a convention on transparency in investor-state arbitration as a consequence, as a result of its work on model rules on transparency in investor-state arbitrations. A very interesting project which, if you can participate or follow, you will see the international push for arbitration in the role. Online dispute resolution. You mentioned, Jean-Michel, online contracts. Online contracts, and if something goes wrong, will the seller accept to take the products back? Will I get reimbursed? What if this does not happen? Do I go to court? For how much am I prepared to go to court? For a product worth $200, $300, $400? I probably won't go to court, but then I would still need to have some kind of process to have an online dispute resolution. Basically negotiation and mediation, in very few cases arbitration. This is the work of Working Group 3. Electronic commerce. UNCITRAL has prepared a number of texts in the area of electronic commerce, electronic signatures, the UN Electronic Contracting Convention. Now, a text, probably model law, on electronic transferable records, which is in a way building on work done by a number of organizations, regional organizations also. Insolvency law. UNCITRAL has prepared the model law on cross-border insolvency, a very successful text, cross-border recognition of insolvency of companies which have assets all over the world, which is to the benefit of all creditors, because in this way, with a coordination, you save costs of insolvency. Otherwise, you have to open insolvencies all over the world, and most of the assets of the insolvency go to pay the expenses of these proceedings. And now we have a colloquium 16 to 18 December to discuss a number of future topics. Future topics include financial insolvencies, include director liabilities in insolvency, IP licenses in insolvency, a number of arbitration in insolvency cases, a number of interesting topics. They are not and the registration form is on our website. Anybody can attend. And the suggestions will then be presented in a report to the Commission for future work in the field of insolvency. I guess the last topic should be security interest. We have built on the organization, on the work of the Organization of American States, on the OAS model law and the OAS regulations, secure transactions regulations, and prepared a guide on security interest, and then a guide on registration, under the leadership of Chairman of Working Group 6 from Mexico, Ambassador Rodrigo Labadini Flores. We are now working on text model law on secure transactions, which in a way will go in a direction, a step further in order to provide guidance to states as to the issues that need to be addressed in the modern secure transactions law. I guess I would stop here. I try to cover as many of parts of the work of UNCITRAL as possible. Other work, public-private partnerships, PPPs, an issue which is discussed also this week in the Legal Justice Development Week at the World Bank. International contract law. Based on the Sales Convention, there is a suggestion to enlarge the scope of the Sales Convention and deal about principles of international contract law, building also on the UNITRAL principles. Rule of law discussion I mentioned is, if you like, our political connection with the rest of the discussion in the UN about the importance of rule of law. Of course, there is a program of technical assistance, which I guess is not as substantial as that of organizations like the World Bank, because our resources are limited, but includes drafting legislation, national legislation, assisting states in drafting legislation based on our text, providing comments, joining forces with other organizations which provide law reform assistance. We have a large number of publications. All of them are on our website. And finally, we have a program coordinate cooperation with a number of academic institutions trying to present our work in the context of law school curricula, and a number of internships for young lawyers, because they are the future. And that's the investment of UNCITRAL in the future of private international law or the law of international trade. Thank you for your attention. I'll be glad to respond to any questions and elaborate further in the discussion on our work.
Thank you.